Hey folks, this is an ERISA Legal update. This part is concerning regulation. I adapted this from a presentation that I gave to the Madison Benefits Council, and I hope that you find it useful. As with the others, this is just a quick survey. It's not intended to explain everything. It's just to flag certain issues, and if it applies to you, then you know that you can dig a little deeper and figure out what you need to do with this information. These are the main takeaways, just in case you fall asleep. I want to get them right out of the way. I'm going to go through 7 different regs, focusing mostly on the top 2, which would be the SEC, or Securities and Exchange Commission, Regulation Best Interest, or Reg BI. That's about broker dealers and their duties towards retail clients, not retirement plans. But as we'll see with that discussion, there's going to be some useful outcomes for retirement plans, some information that retirement plans will be able to take advantage of from Reg BI. And we'll also talk about the Department of Labor, or DOL, which proposed an electronic delivery safe harbor. Its short story is just it's opt out instead of opt in, so you can make electronic the default instead of a paper default. And we'll talk more briefly about the IRS, Internal Revenue Service, released a revenue ruling regarding uncashed checks from a qualified plan, but they do not apply to missing participants, so it's not as helpful as you might have hoped. Then we'll talk about HHS, Office of Civil Rights, the OCR, and their initiative for the HIPAA right of access. We'll talk about CMS and drug manufacturer coupons. We'll go in briefly discuss the EEOC wellness regs and where the heck are they. And then we'll touch on the New York Department of Financial Services, the DFS cybersecurity regulation, which is now in force. These are some of the other topics that the other parts cover, including legislation and litigation. If any of that sounds interesting to you, go ahead and click over and see what you can make of it. All right, so focusing on regulation, starting with just a quick review. Those are the 7 we're going to look at, mostly the top 2. SEC Regulation Best Interest, or Securities and Exchange Commission, is the SEC. Reg BI is what everyone has been calling it. It is for retail clients. It is not for retirement plans or qualified plans or ERISA plans. We're not the target. But that said, there are going to be some useful effects. So it applies if a plan participant is given a recommendation by a broker-dealer concerning rollover, transfer, or distribution of plan assets held by the participant. So those plan participants count as retail clients for the broker-dealer for purposes of Reg BI. So there's relatively little overlap between plans, but it will protect at least our participants. So that's nice to hear. It is overall much less ambitious, or somewhat less ambitious, than the DOL fiduciary rule, which was the subject of litigation until it was suspended and then it was withdrawn. The DOL stopped pushing for a follow-on to the fiduciary rule and sort of ceded ground to the SEC, and now the DOL is saying that they'll have regs following Reg BI that will should conform with it, should align. So we'll see what those look like. Those have not come out yet in even proposed form, but we'll see what they have to say, if they have any additional requirements or expectations. But for now, if we just look at Reg BI, now, if any of you are broker dealers or have advised broker dealers, you would know this much better than I would. But just at a very high level, it requires that broker dealers act in the best interest of retail clients in making recommendations in certain situations. It requires written disclosure of fees and conflicts, written policies and procedures regarding conflicts and complying with Reg BI, requires the broker-dealers to mitigate and disclose certain conflicts of interest, and to disclose other limitations, for example, if they favor proprietary products. It requires them to eliminate certain sales contests or bonuses or quotas for employees based on the sale of certain products within a set period of time. Does not require all of those contests, bonus, and quotas to be eliminated. There are certain such arrangements that are prohibited, and those would be affected, but not all of them. So if that is something that you're interested in, you can dig into the details a little bit. What it will also require is Form CRS, which is a relationship summary. That's going to list conflicts and other disclosures, and it's going to be publicly available. So even though Reg BI does not directly help the retirement plan space, this is going to be useful to qualified plans, retirement plans, ERISA plans. We're going to be able to get a little bit of use just out of reading the Form CRS, the relationship summary. It won't be provided to the plans. It won't be provided to participants generally, not even if you are using a broker-dealer in your self-direct window or a managed account. But if a participant, a plan participant, is going to hit one of those retail client situations like rollover, transfer, distribution, you're deciding between different broker-dealers' advice, then they would potentially get a Form CRS, relationship summary. So the takeaway is that this is going to protect retail clients, and only narrowly will it affect how broker-dealers handle plan participants. But there will be conflicts policies, and there will be this relationship summary. And my advice to plans out there is whether you're advising plans or you're an employer or a plan sponsor, you can look up that Form CRS that'll be publicly available, and you can also ask your vendor or your potential vendors in an RFP or just in the middle of an engagement. You can ask them, what's your conflict policy? What have you been doing? Do you have any of these sales contests, bonuses, and quotas? Did you have to eliminate any? Did you retain any? What are the conflicts of interest that might be relevant here? You can ask, and you can see what they would say. Reg BI does not directly uh, protect the plan, but to the extent they're already doing this work, or these are just reasonable questions that you can ask in an RFP, these are, these are things that maybe you could incorporate into your relationship with a vendor. So some interesting stuff there, and we'll see how it develops. Now, the DOL has proposed a new rule. It's an electronic delivery safe harbor. And again, it's just proposed. It's not final, so don't get ahead of yourself. Uh, the, the short way to describe it is you can leave someone on electronic notice as a default and they opt out. The previous guidance was you could get people to opt in, but they had to get paper as a default. And then the exception was current employees. You could require them to take electronic. Now, that 2002 safe harbor, which is still current, that's not going away. At least the DOL says they don't intend to get rid of it. So you can still rely on that. So really what this means is for people who are not current employees, you might be able to move to electronic disclosure as a default. And the basic idea is you're maintaining their contact information, whether that's email or a text or some other electronic method of communication. The DOL is trying to be neutral. They don't want to pick a form of communication that becomes obsolete in 5 or 10 years. So they're staying neutral and vague. But you maintain that contact information, you send them a notice of internet availability, and then they can use that notice and either click on something, or they can otherwise follow your instructions and go look up the notice on a website or otherwise. So really what that's just saying is, hey, go check the website. Now, there are some rules that the DOL has suggested on whether you can combine these notices, and basically where they are right now is saying if it's a regular notice that's just triggered by the passage of time, like an annual notice, then you can combine all those together. You can just send one notice for all of them and say, hey, go check out our notice package, it's ready, and then they get that text or that email or whatever, and then they go look it up. Whereas if it's triggered by a special event, then that would not be a situation they want you to combine. They want you to spell that out separately. They don't want it to get lost in the shuffle, I think. So a lot of combining would be allowed, but they don't want you to just combine everything. They don't want everything to get lost. There is a question of what is this website? Who's going to run it? What's it going to look like? They had some rules that it has to stay available, it has to be text searchable. If it has personal data, it has to be protected. There is a question if we're dealing with non-employees, or at least not current employees. So, your employer intranet might really not be appropriate. So are we talking about a third-party website? Is this something a vendor might provide for you? Would you have to provide multiple different vendors? Maybe you could point to all of your disclosures for one vendor and point to their website, and then for another vendor you could point to their website. But someone would have to log in and they would have to pursue it that way. You probably wouldn't want to just have an open website, right? You wouldn't want to just make all of your disclosures completely available. But if you did, that would certainly be relatively easy on the administration side. So just as a takeaway, remember this is proposed, it's not final. In general, it's good that we're moving towards opt out and start thinking about your procedures for how you're maintaining contact lists when an employee turns into a former employee. Are you getting emails? Are you getting uh, some sort of electronic communication info? Is there something you're doing to gather it? And are you occasionally updating it? So, something to think about. Right, so the IRS released Revenue Ruling 2019-19, and for those of you who work a lot in ERISA, just remember that Rev Rule 2019-19 is not Rev Proc 2019-19. That is the revenue procedure. Same numbers, but the revenue procedure is EPCRS. So don't get them confused. It's easy to confuse. They're almost exactly the same, other than ruling instead of procedure. This is about uncashed checks. So simple story is just this is if you send a check to somebody and they got it and they don't cash it, you ignore the fact that they didn't cash it. So pretty basic tax rule, right? You can't just leave a check in your envelope or leave it in the mailbox for a week and then, from December 30th to January 2nd or whatever that you get to delay it a tax year, right? It doesn't work like that. You can't just decline to cash a check for a few weeks and then get a new tax year. Same principle here. If you know they got the check, then you have to, for the distribution from your qualified retirement plan, you have the same withholding obligations. You have the same 1099-R obligations. So that doesn't change anything. The hard part is if you don't know they got it, they might be missing. If it's a missing participant, then that is a different rule, right? They didn't get it. So that's not constructive receipt. So unfortunately, this revenue ruling does not address missing participants. It leaves a little TBD. They leave a little IOU in there, like, oh, we'll get back to you on that, and obviously they haven't, because that's an incredibly thorny issue. So no, they haven't gotten back to us, obviously. But in the much more common situation with a missing participant, you would just have to follow your missing participant rules. But if you happen to know someone calls you up and says, I refuse to cash, or they try to mail it back to you, or maybe they shred it up and send you a picture, you know they got it, then you would treat it as if they cashed it, even though you know they didn't. So CMS, which is part of HHS, they have these drug coupons that they have been trying to figure out how to price, and they released some guidance about when you can ignore them. Unfortunately, the guidance conflicted with, if you have an HSA, it conflicted with high deductible only health plan coverage. So the three agencies that run ACA, ACA enforcement and interpretation, they released FAQ 40, and Part 40 just said, yeah, whoops, we're taking that part back. So they're redoing it to the extent it's conflicting with HSAs and high deductible health plan only coverage. Essentially, what these coupons are is drug prices are so high that a lot of the manufacturers will issue coupons, and that's inconsistent, according to the IRS, with high deductible health plan only coverage. That's not high deductible health plan. Now there's a separate issue of when does a health plan even know that you're using a coupon? Often it's not reported. So if it's something that the pharmacy and the participant and the manufacturer are doing and none of them report to the plan, then I mean that's just sort of a failure in the system. But to the extent that a plan knows about it, the IRS says that is not HDHP only. So we'll see if there's any more on that. Probably not a lot for plans to do, for HSA plans to do. Then another part of HHS, the Office of Civil Rights, they're enforcing HIPAA, and they've got an initiative for the right of access. OCR is responsible for enforcing HIPAA, including those individual rights. Right now, they are going after health providers, which is generally what OCR does with HIPAA. They really like to focus on hospitals and doctors and clinics and so forth. But health plans, ERISA self-funded group health plans, are also HIPAA-covered entities and can be investigated and penalized and fined. by HHS OCR. So this does apply to those health plans out there that are covered entities. In case you don't know, HIPAA's individual rights are the right to appoint an authorized representative, the right to access of your PHI, the right to amend your PHI, the right to an accounting of the uses and disclosures of your PHI. For those who don't know, PHI is protected health information, basically private health information under HIPAA. But you also have the right to restrict communications, the right to a confidential means of communications, the right to get paper instead of electronic communications, and the right to complain. So those are all different individual rights under HIPAA that participants have. And so if you are a HIPAA entity, such as an ERISA group health plan, go ahead and review for compliance, make sure that you've got some language on your individual rights, make sure it's in your BAA template and things like that. But the larger context here is privacy, right? So between HIPAA, but also CCPA and GDPR, we've got a real privacy trend going. So I just wanted to flag this because it's part of that larger trend. Then EEOC, where are those wellness regs? Well, we don't know. They keep saying they're coming. They keep delaying. Lucy just keeps putting that football out, but no, it's not looking very likely. So these regs were struck down after litigation with the AARP, and the basic question is, if you have a wellness program and it offers a cash incentive, how big can that cash incentive be before it's so big that you're basically compelling disclosures of health and genetic information, that a disclosure of such information is no longer voluntary because so much money is at stake. And of course, ADA and GINA prohibit disclosures of health and genetic information unless it's voluntary. So if your incentive is so big that essentially it's a penalty for failure to disclose, the understanding is that it's no longer a voluntary disclosure. So EEOC had said 30% of premium is voluntary, 50% in the case of tobacco, and they just took that out of the ACA. And the court, after litigation by the AARP, the court said, no, that's just because it's in the ACA doesn't mean it's appropriate, that's arbitrary. So EEOC has been delaying new regs for several years. Probably, they keep blaming delays in staffing and appointments. So their original goal was 2021, and the court said no, but every earlier deadline the EEOC has so far failed to meet. So we'll see. Until it comes out, we don't have a safe harbor. We don't expect EEOC to enforce until they get their reg out, but there's a litigation risk. So if you go to the part where I discuss litigation, there already is litigation. AARP did sue Yale over their wellness incentive. So that is the risk until we get these regs. And just to end up on the New York Department of Financial Services, DFS regulates, financial institutions, banks, insurers, etc. And they have this cybersecurity regulation. It pertains to data security, and it has been enforced now. And as of last year, there's a new cybersecurity division at DFS, and they're just enforcing this regulation. And so everyone is expecting further enforcement, but also hopefully further clarification of the DFS cybersecurity regulation, especially the breach notification timeline and exactly how that works with vendors. And if you're in this space, you might already be aware of the issue. And if you're not in this space, you probably just don't care. But briefly, the breach notification timeline is within 72 hours, not business days, nothing like that, just 72 hours. You have to notify DFS of certain breaches. The question is, does that clock start when your vendor, who's holding, say, plan information, gets the breach, or does it start when the vendor tells you? Now, since the vendor is in a contract with you, you could have a contract that requires them to tell you immediately, or it requires 24 or 48 hours. So everyone's sort of assuming that DFS will will append the timeline together, and that somehow covered entities under this regulation will be expected to bind their vendors, but they haven't been explicit about it yet, so it's not exactly clear. But just like with the HIPAA, I would expect more privacy emphasis in the future. So that's really why I've included this, even though a lot of people are not necessarily going to be regulated entities under DFS. So there you go. That's regulation. Now let's just do a quick review those takeaways, right? Remember, we talked about SEC, the Reg BI, and how it's not going to directly help plans. It will help the participants when they're doing distributions and rollovers and transfers. But there is going to be some information out there, and you can request those policies and procedures from your vendors or potential vendors in an RFP. And you can look up Form CRS and get that. That'll be publicly available. The DOL also proposed that electronic delivery safe harbor, so we'll see if that goes final. And then we talked about all of those other issues as well, and hopefully, if any of those apply to you, you'll be able to get more information. In other parts, I talked about legislation and litigation, and if any of that sounds interesting to you, go ahead and click on over. But otherwise, I hope you enjoyed it, and thank you so much for your patience.